Chapter 5 of Joint and Several Bonds. Two or more persons may bind themselves jointly or severally, or both jointly and severally, according to the language of the bond, but a person cannot be bound to several persons severally, and therefore, if an obligation be made to two persons in the sum of 200 litres, £100 to be paid to one of them, and the other £100 to the other, the part as to the payment is void. If the obligation be joint, it will be attended with all the consequences of a joint contract. Thus, in suing upon the bond, all the obligors must be joined, unless some of them were incapable of executing a valid bond, as in the case of a married woman, or an infant. The omission, however, of a joint obligee is not a ground of demurrer, unless the defect clearly appears on the face of the declaration, but in other cases it should be pleaded in abatement. So, also, all the obligees must join in the suit, and upon the death of one of them, the survivors alone can sue thereon, even though the bond is conditioned for payment to the deceased party, and the survivors have no interest in the sum contained in the condition. In like manner, upon the death of one of several joint obligors, the action should be brought against the survivor, and the executor of the deceased cannot be joined. A release by one of several obligees will operate as a bar to all. So, a release to one of several obligors may be pleaded in bar by the others. If the bond be several, the liability of each obligor several is separate and distinct, and therefore the tearing off the seal of one of them will not avoid the bond as to the rest. Where three persons entered into a bond for the payment of 1,000 litres, and the words used were for which payment we bind ourselves, and each of us for himself, for the whole and entire sum of 1,000 litres. Each, the word each was held to render the bond several only. If two or more persons bind themselves, and each of them, the obligation is joint and several. Also where a bond executed by three persons commenced with the words, "Know all men, that we are bound," and c. but proceeded, "For payment whereof I bind myself, my heirs, executors, and administrators, by these presents sealed with our seals." This was considered to be both a joint and several obligation, and in this case the obligee may sue all jointly, or any one of them, at his election, and if he sue them separately, the recovery against one will be no bar to his proceeding against the others, unless he has obtained execution. A discharge of one joint and several obligor will operate as a discharge of all. And where a release has been given to one of several obligors, the obligee cannot plead that it was given upon an express understanding that it should not prejudice his right or remedy against the others, for the legal effect of an instrument under seal cannot be altered by parole agreement. So, if several are jointly and severally bound, and the obligee make one of them his executor, and he administers, this will operate as a release of the debt at law, for a personal action once suspended by the voluntary act of the party entitled to it, is gone forever. And the same consequence will follow whether the obligor be sole executor, or with others. Also if the obligee make the wife of one of two joint and several obligors his executor, this will operate as a release of the debt. But if the obligee make the executor of one of the obligors his executor, the debt is not discharged, for the executor holds it in another right, and he may sue the surviving obligor. And where to debt on bond by executor of obligee against executor of obligor, the latter pleaded that the money mentioned in the condition was part of the personal estate of A. B. deceased, by whom it had been bequeathed to the testator of the plaintiff and the testator of the defendant and the survivor of them, and the executors and administrators of such survivor, upon trust to put and place the same out at interest, upon such real or other sufficient security as they might approve of, that the testator of the plaintiff died, leaving the testator of the defendant surviving, whereupon the said personal estate of the said A. B. vested in the defendant's testator, to be by him and his executors and administrators applied according to the trusts of the will of A. B. The plea was held bad upon demurrer. If one of several persons jointly and severally bound make the obligee executor, and the latter has assets and administers, the debt will be released in law. So also if one of the obligors make the executor of the obligee his executor and leave assets, the debt is deemed satisfied. But if the obligee have no assets the debt is not extinguished, and he may sue the heir if named in the bond, though it seems if he pay himself any part of the debt he cannot sue the heir for the residue. Though without the obligee administers, the debt will remain, and therefore where one of two joint and several obligers appointed the obligee and another person his executors, which latter person administered, but the obligee refused, and having afterwards died, left the person who had administered his executor also, it was held, that the executor might maintain an action against the obliger. And where a bond was given to husband and wife, and the obliger made the wife his executrix and died, and she after her husband's death sued as his executrix, the action was held to be well brought, for by suing as executrix of her husband she waived her right to survivorship as joint obligee. It should be observed that the principle of the above doctrine is, that a remedy suspended by the voluntary act of the party is gone forever. Therefore if the suspension be caused by the act of law, there will be merely a temporary privation. Thus if the obliger take out administration to the obligee and die, the administrator de bonis non of the obligee may, nevertheless, maintain an action for the debt against the executor of the obliger. So if the executor of the obligee marry the obliger, such marriage is no release of the debt, but the remedy is only suspended during the coverture. A covenant not to sue a single obliger may be pleaded as a release, but as such covenant does not operate as a release in its own nature, but only by construction, to avoid certity of action. If the obligee covenant not to sue one of two joint and several obligers, he may, notwithstanding, proceed against the other. And if the covenant be not to sue for a certain time, it does not amount to a defeasance, without it forms a part of the same instrument, but is merely a covenant, for the breach of which the obliger may maintain an action.